In this video, I want to take a look at where you go with appeals in relation to employment disputes. So, as you know, you bring most employment disputes, for example, for unfair dismissal or for a whistleblower complaint or something of that nature, Organisation of Working Time Act complaint, you bring it to the WRC. If you're not happy with the outcome there, you bring an appeal to the Labour Court. But what happens if you go to the Labour Court and you're not happy with the Labour Court either? You have a further appeal. The further appeal is to the High Court, but on a point of law. On a point of law. What does that actually mean? There's a recent enough case there in April of 2019, I think, is the decision that was handed down from the High Court. It involved a gentleman who worked for the Department of Employment and Social Protection. He had been disciplined, I think, at the WRC or in the workplace, and he brought a claim to the WRC. He wasn't happy with the outcome there, and he brought the appeal to the Labour Court. He wasn't happy with the outcome of the Labour Court appeal, and he brought a judicial review claim or case to the High Court. So basically he was asking the High Court to look at the case, and he appealed to the High Court on 10 points of law. In other words, he alleged that the Labour Court had made a mess of his case on 10 points of law, because remember, he can only go to the High Court on a point of law, not on the substantive issue. It's useful though to understand and to recognise what the High Court has found in this case, because it gives a good synopsis, a good clarification or confirmation of appeals in such cases. So the High Court firstly looked at its jurisdiction to deal with appeals from the Labour Court. It noted that it could only concern itself with issues of law. What does this mean? What does issues of law mean? Firstly, it means that the High Court cannot concern itself with the substantive claim. In this particular case, the substantive claim was that he had been penalised in the workplace for having made a protective disclosure, I understand. But the High Court cannot concern itself with the substantive claim that was brought to either the WRC or the Labour Court. It can concern itself with points of law. It looked then at what that actually means, and it referred to the Supreme Court's consideration of the issue in the Nano-Nagel School versus Marie Daly case of 2019. The Supreme Court held that the issues that could be considered were: number one, findings of primary fact where there's no evidence to support them. Two, findings of primary fact which no reasonable decision-making body could make. Three, inferences or conclusions which are unsustainable by reason of any one or more of the matters listed above, or which could not follow or be deducible from the primary findings as made, or which were based on an incorrect interpretation of documents. These are the issues that the High Court can look at when it's deciding on how a Labour Court or the Labour Court conducted itself. But it cannot go into the substantive issue. Essentially, it is looking at the administrative tribunal and whether there was a failure of compliance with the statutory duty of that tribunal. The High Court noted that it cannot substitute its judgment for that of the Labour Court, even if it wanted to. The High Court can look at the procedures and processes followed by the Labour Court in making its findings of fact, and to consider whether its decision is sustainable at law. That's what the High Court can do when it's reviewing a Labour Court decision and a judicial review and appeal on a point of law to the High Court. So the High Court in this case found that, quote, the Labour Court acted in accordance with the requirements for fair procedures. The appellant was present, heard directly the evidence against him, and was afforded an opportunity to challenge it. The High Court dismissed the appeal, determining that the facts or the findings of fact made by the Labour Court were supported by the evidence, and the provisions of the Protected Disclosures Act 2014 were correctly interpreted and applied. So if the Labour Court interprets correctly the law and comes to reasonable findings of fact findings of fact that are not perverse or irrational, that are based on the evidence, where the Labour Court hears the evidence of both parties, then the High Court cannot interfere and will not look at the substantive issue. So, employment dispute, employment claim, you go to the Labour Court, you go to the Workplace Relations Commission, you appeal to the Labour Court, you appeal to the High Court on a point of law, but on a point of law only. So you appeal from the WRC to the Labour Court, and it's a hearing de novo, that is from scratch. You get to run the case again essentially, but when you go to the High Court, you're not running the case again. You're looking at any imperfections or infirmities in the way that the Labour Court conducted the hearing, and you are bringing your judicial review appeal on a point of law. I hope you find this video useful. If you do, you might give it the thumbs up down below, and if you want to go into that case in more detail or find out more about it, if you go to my website employmentrightsireland.com, you'll see a blog post there from April 19th of 2020, Whistleblowers Appeal of Labour Court to the High Court on 10 points of law dismissed. That's where you'll find it, and you'll find the full decision from the High Court. It's useful because it's useful to know that if you appeal a decision, what can the High Court or what can the Labour Court at the various stages of appeal deal with? And the High Court cannot deal with the substantive issue, only points of law, only if the Labour Court messed up from the point of view of interpreting or applying the law. Hope you find this video useful. If you do, you might give it the thumbs up down below, and you may be interested in subscribing to my YouTube channel.